By Wilmer Velasco.
Wait.
Good morning. We are here today for a bail hearing. The court is in receipt of the Nevada pretrial risk assessment, which indicates that the defendant scored as a 13 or a higher risk utilizing that tool. The defendant is present using an ASL interpreter. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. The state is seeking $5,000 in bail, along with pretrial services supervision, with testing for controlled substances, as well as a no contact order with the victim. The state believes that amount of bail and those conditions are necessary based on the defendant's high risk of 13, as well as his 2 points for failure to appear. The defendant has a conviction for camping on public property this year out of Reno Municipal Court. During the pendency of that case, he failed to appear and a bench warrant had to be issued for his arrest. Last year, he was convicted of trespassing and a battery out of Reno Municipal Court. He is currently still under a sentence for that battery case. And he did have a bench warrant issued for his arrest for failure to comply post-sentence. The defendant has a very lengthy criminal history. It looks like the majority of convictions are for misdemeanors, but they do include crimes of violence such as battery. So based on his recent compliance issues, as well as his high risk assessment score, the state believes that the bail and those conditions are necessary.
Thank you. State, do you have the full name of the named victim?
Yes, Your Honor. First name is spelled Arryon, middle of Ann, Ann, and then last of Peterson with an ON.
Thank you. Can you spell the first name again?
Yes, it's Aryon.
Thank you. Defense?
Yes, at this time, we're seeking a lesser amount in bail to the effect of $2,000 bondable with a 10% cash option. That's primarily premised on the types of charges that have arose. One is simple possession, which lends to an eye towards treatment rather than continued incarceration. And then the other charge is a low-level misdemeanor that is nonviolent in its classification. Looking at his background and the circumstances of this offense, it's clear that Mr. Drummond has some issues that need to be addressed through a treatment lens. I believe it was mentioned previously that he might be a worthwhile candidate for the STAR program. So in any manner that we can start seeing, maybe screening Mr. Drummond for those alternatives, I think is the closer we would get to, I guess, remedying these underlying issues that Mr. Drummond is experiencing. In the event that we can't do a pre-screening for the STAR program, whatever that measure is, I would ask for an alternative of direct transport to a treatment program with a qualifying SAE on file.
Thank you. State, do you have any objection to setting a pre-sentence screening for the STAR program?
No, Your Honor.
Thank you. Madam Clerk, if we could note that for the record, there's no objection by both parties. Okay.
No, that's right.
Based on the facts as presented, the Nevada pretrial risk assessment, and the factors as outlined in NRS 178, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in order to ensure the safety of the community and the appearance of the defendant. Bail will be set in the amount of $2,000. That is based off of the higher Nevada pretrial risk assessment, the likelihood of conviction, the compliance concerns, and failure to appears. I am requiring that if the defendant is able to post that bail amount, that Mr. Drummond be supervised by pretrial services. He must check in within 24 hours of release. He cannot use any controlled substances or alcohol unless he has a valid prescription. And be subjected to random drug and alcohol testing. The court finds there is a sufficient nexus based off of the allegations. Additionally, the court is imposing a no contact order that begins immediately with the named victim. So, sir, you cannot contact the victim in any way and must stay 100 feet away from her. Cannot contact or attempt to contact her, including in person, by phone, text, email, electronic means, or through social media, either directly or through an agent. That means someone working on your behalf. We will set a 72-hour hearing in this case. And that will be set for August 28th at 9:30 a.m. And we will set that pre-sentence screening. And Madam Clerk, when will that be?
August 25th at 9 a.m.
Thank you.
For Star Program, correct?
Yes. Madam Interpreter, would you possibly be available for a Zoom meeting for that if necessary at that time?
We can, the interpreter will need to write down the dates for both the pre-screening and the next court date. May the interpreter have those times again, please?
Yes. The pre-screening is August 25th at 9 a.m. The 72-hour could change though. So the 72-hour hearing is August 28th at 9:30.
Okay, I will give that to my boss, and I'm sure we will have someone available.
Thank you. And that concludes this hearing. Thank you.
Thank you so much.
Thank you, Madam Interpreter.
Does the public defender need me to stay on for after the court to discuss anything with Joseph?
No, not at this time. I provided him a note with sufficient information.
Okay, great. Thank you so much. You have a super day.
Thank you, too. Next, we have Wilmer Velasco, followed by Leroy Cantley.
Ahora tenemos a Wilmo Velasco. Good morning, Your Honor. Jimena Fini, certified court interpreter Spanish, NVF XP 610.
Good morning. Good morning. We are here today for first appearance bail hearing.
Buenos días, estamos aquí hoy día para la comparecencia inicial, audiencia de fianza.
Probable cause has been found and the public defender's office has not been appointed to represent you yet.
Se ha encontrado motivo fundado y la Oficina de Defensores Públicos no ha sido nombrado aún para representarlo.
Sir, how much money do you make per week if you are in custody?
Señor, ¿cuánto dinero gana por semana si usted no estuviera detenido?
¿Yo?
Está detenido, perdón.
Ok, 2 days por $252 en landscaping.
Okay, $252 for landscaping.
Yeah.
Thank you. The court does find that you qualify for the services of a public defender, so the Washoe County Public Defender's Office will be appointed to represent you.
Ok, gracias. Entonces encontramos de que usted sí califica para los servicios del defensor público con la Oficina de Defensores Públicos del Condado de Washoe y se le va a nombrar uno para que lo represente a usted.
Okay.
The court will note that the defendant is present utilizing the services of a previously sworn and certified Spanish interpreter.
Vamos a notar de que el acusado está presente utilizando los servicios de una intérprete jurídica.
The court will note that given the information provided in pretrial services report, there is no Nevada pretrial risk assessment, but a criminal history was run.
Vamos a notar que dada la información que se ha dado en los servicios previos al juicio, que en la evaluación de riesgo de Nevada no se vio lo de antecedentes penales.
State, please proceed with the bail hearing.
Por favor, proceda con la audiencia para fijar fianza.
Thank
Okay.
you. Your Honor, state is seeking $10,000 in bail along with pretrial services supervision.
Gracias, su señoría. Lo que estamos pidiendo es $10,000 de fianza con la supervisión previa al juicio.
We are seeking conditions of a no alcohol and daily testing,
Estamos buscando las condiciones de que no puede consumir alcohol y que se le hagan pruebas a diario.
Okay.
as well as no firearms or weapons possession.
Tampoco que él pueda poseer ningún tipo de armas ni armas de fuego.
That is based on the facts of the case as outlined in the probable cause declaration.
Eso está basado en los hechos del caso, también como lo señala en la declaración de motivo fundado,
Which outline the defendant's flight while driving under the influence,
que también va a destacar que el acusado iba manejando mientras estaba bajo los efectos del alcohol,
flight after being pursued by law enforcement,
huyó cuando lo estaba persiguiendo los oficiales,
and the significant use of force against the law enforcement officer when he was apprehended.
y también el uso de la fuerza en contra de un oficial del orden público cuando lo iban a aprender.
Clearly, the defendant's intoxication played a role in part of the incident.
Claramente el acusado, siendo que está en estado de intoxicación, eso tomó un rol grande en esto.
We don't have any information as to the defendant's ties to our community.
No tenemos información de los lazos del acusado aquí con la comunidad.
However, I will tell the court that his criminal history did not show any convictions.
Sin embargo, quiero decirle al tribunal de que sus antecedentes penales no mostraban ninguna condena anterior.
However, based on the facts of the case, the state believes he presents a danger to our community and our law enforcement.
Sin embargo, basándose en los hechos de este caso, creemos de que él es un peligro para nuestra comunidad y para nuestros oficiales del orden público.
And therefore believe that bail in those conditions are appropriate.
Por lo tanto, creemos que la fianza en esas condiciones es apropiado.
Okay.
Thank you.
Gracias, defensa.
Yes, at this time, we're seeking an OR release with appropriate release conditions. I think the suggested conditions of regular alcohol testing would be appropriate along with check-ins.
Bueno, creo que en este momento lo que estamos pidiendo es que él salga en libertad bajo palabra de honor, bajo las condiciones de libertad apropiada. Creemos que las condiciones puedan ser de que es apropiado de que él se le hagan pruebas regulares por consumo de alcohol, también que él se esté reportando regularmente.
In speaking with Mr. Velasco, he represents to me that he does currently work in landscaping locally. He also has a place he could return to locally, and he also has a telephone number.
Yo hablé con el señor Velasco y él me ha representado de que él sí trabaja actualmente como jardinero aquí localmente y que él también tiene un lugar donde regresar aquí localmente.
Yes.
And while the allegations are troubling, as noted by the state, I think his lack of prior criminal convictions and seemingly this being his first arrest warrants an OR release at this time.
Ahora, mientras que estas acusaciones son problemáticas, como lo ha nombrado la fiscal, creemos también de que la falta de antecedentes penales, condenas anteriores, siendo este su primer arresto.
The state mentioned previously that in some part his conduct was fueled by intoxication. I would argue this is completely a result of his intoxication, which can be quelled with supervision conditions as a least restrictive means.
Ahora, como lo nombró la fiscalía anteriormente como parte de su conducta también, esto fue debido a la intoxicación, estaba en estado de embriaguez, y también yo diría de que como consecuencia de esto puede ser de que él tenga, si él cumple con las condiciones de supervisión, eso sería un medio menos restringido.
This is further reflected in his lack of criminal history and the absence of any record of non-compliance. So with that, defense will submit.
Esto va a reflejar la falta de antecedentes penales de él y también la ausencia de que él no tenga en sus antecedentes de que no cumple. Con eso lo voy a dejar, lo presento a su señoría.
Thank you.
Gracias.
The court finds that the state has not met its burden and is granting own recognizance release here today.
El tribunal reconoce de que la fiscalía no ha aprobado el peso de la prueba, por lo tanto lo vamos a dejar a usted en libertad bajo palabra de honor hoy.
So, sir, you will be released, but you will be required to be supervised by pretrial services.
Señor, usted va a salir en libertad, pero usted va a tener que estar reportándose con los servicios previos al juicio.
And you
Yes.
must check in with them within 1 business day of release.
Tienes que hacer eso un día después de que usted salga en libertad.
You are required to not use any controlled substances or alcohol or unless you have a valid prescription.
Se requiere de que usted no consuma ningún tipo de sustancias reguladas o alcohol, a menos que sea una receta médica válida.
And be subjected to daily alcohol testing.
Y usted va a estar sujeto entonces a que le hagan pruebas por consumo de alcohol a diario.
And it will be for alcohol only. That is where there's a sufficient nexus.
Y va a hacer alcohol solamente.
Okay,
You will be
alcohol.
required to conduct and to do what we call the DUI rant.
Ok, usted está requerido entonces de que usted tiene que estar le van a hacer tiene que estar reportándose por lo del DUI, por sus siglas en inglés.
And pretrial services may remove the testing requirement if you are a low risk.
Ahora, si usted sale que es riesgo bajo, los servicios previos al juicio puede que quiten entonces ese requisito de que usted tenga que hacerse pruebas a diario.
You
Okay.
will be required to do 3 mutual support groups. So that's things like AA or NA, the non-secular version groups per week.
Se va a requerir de que usted tiene que estar en 3 grupos de apoyo, que puede ser Alcohólicos Anónimos, Narcóticos Anónimos o alguna versión no secular, que tiene que ser por semana a esos grupos que tiene que ir.
Okay.
And those conditions are due to community safety and as least restrictive means.
Y esas son las condiciones para garantizar la seguridad de la comunidad y es un medio menos restringido.
We will set your arraignment, which is set for September 10th at 9 a.m.
Vamos a fijar su lectura de cargos entonces para el 10 de septiembre a las 9 de la mañana.
You must appear in Reno Justice Court on that date and time, comply with all these conditions, obey all laws, make all future court appearances, or else a bench warrant will be issued for your arrest.
Usted debe comparecer al Tribunal de Justicia de Reno en la fecha y en la hora y cumplir con esas condiciones. Y tiene que usted comparecer en cualquier audiencia en el futuro o si no se va a dar una orden de aprehensión judicial en contra de usted.
Okay, señorita, ¿cuándo empiezo Alcohólicos Anónimos? Okay.
Okay, Miss, when do I start AA?
So you were to start that this week. So when you're released, you will be required to do it for this week 3 times per week, and then you have to do that continuously until this case is concluded.
Señor, usted tiene que empezar entonces esta semana hasta que usted salga ya a libertad y usted va a estar cumpliendo con ellos. Son 3 veces por semana hasta que entonces usted después continuamente hasta que su caso concluya.
Okay.
Thank you.
Gracias.
And thank you, Madam Interpreter. I believe that is all the cases we have with you this morning.
Thank you, Your Honor. Bye-bye.
Thank you.
Thank
Next,
you.
we have, thank you. Next, we have Leroy Cantley, followed by Claudia Games.
I spoke with Mr. Cantley this morning. I would ask to waive his appearance and proceed with the bail hearing.
You will go ahead and waive his appearance for today's proceeding. We are here today for a bail hearing. The court is in receipt of the Nevada pretrial risk assessment. I believe, my apologies. We did just get that. My apologies. We are in receipt of the Nevada pretrial risk assessment, which indicates that he scored as a 10 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, state seeking $5,000 bail along with pretrial services and check-ins.
Judge, I would like to just interject. We will stipulate to that bail amount.
Thank you. I appreciate that. Madam, or Ms. Casa, what is that? So it's $5,000 bondable. And what conditions?
With pretrial services, supervision, and check-ins.
Thank you. And then I believe that that's with the challenge to fight with the deadly weapon. What is that category?
I can tell you for sure, Your Honor, after reviewing the probable cause, that won't be charged, but it is a category B offense. But there is not sufficient evidence to charge that, but that is a category B.
Thank you. Would you like that to no 10% cash option at this time?
No, I don't believe it's necessary. He has a district court case that he was just put on probation for, so he has a lot of supervision going on. So I don't believe it'll be necessary.
Thank you. I appreciate that. Based off of the stipulation of the defense, the court will set bail amount of $5,000 bondable with a 10% cash option. The court does find that that is fair and appropriate given all the facts and circumstances. Additionally, and that the state has met its burden, and that the condition will be that the defendant be supervised by pretrial services and must check in within 24 hours of release. We will go ahead and set that 72-hour hearing, and that will be set for August 28th at 9:30 a.m. Thank you. Claudia Games, followed by Katarina Griffin. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 7 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, based on that 7 and her limited prior criminal history, the state's not going to object to releasing her on her own recognizance. We are asking for pretrial services supervision, though, based on the category of offense.
Any other conditions?
Other than check-ins, no, Your Honor.
Thank you. Defense?
We are seeking that OR release, and we have no objection to the suggested conditions.
Thank you. The court does find that the release restrictive means that can be imposed in order to ensure the safety of the community, so you will be granted an own recognizance release here today. You will be required to be supervised by pretrial services, so you must check in within 1 business day of release. And you are required to appear for your arraignment, which we set for September 10th at 9 a.m. So you must appear in Reno Justice Court on that date and time, comply with all these conditions, obey all laws, and make all future court appearances, or else a bench warrant will be issued for your arrest. Do you understand?
Yes.
Thank you. Next, we have Katarina Griffin, followed by Andres Martinez. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 12 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, the state is seeking $1,000 in bail for this defendant, along with pretrial services supervision and testing. That is based on her higher risk assessment score. In addition, you can see that she has 2 points for failure to appear, the maximum number of points. The defendant was just convicted earlier this year of possession of drug paraphernalia out of Reno Municipal Court. Her sentence for that case was to attend self-help meetings, a group and meetings, and she is ordered to show proof of that by August 27th. Obviously, the fact that she is caught in possession of more controlled substances while under that sentence is concerning to the state. She has another possession of drug paraphernalia conviction in 2025, or two of them, one out of Reno Justice Court, one out of Reno Municipal Court. That one out of Reno Municipal Court does reflect a failure to appear at sentencing, and a bench warrant had to be issued for her arrest, and she admitted to it. And then she has an older trespassing in 2018 out of Las Vegas Justice Court. So not a significant history, but certainly has compliance issues and continues to pick up the sort of same sorts of cases. So the state does believe a small amount of bail is appropriate, seeking that $1,000 with testing.
Thank you. And would you have any objection to a pre-sentence screening for the STAR program?
No, Your Honor.
Thank you, defense.
At this time, we're seeking an OR release with appropriate release conditions. I think random drug testing and NAs would be an appropriate start. I think adding the drug testing would be a successful way to heighten the level of supervision, but also curtail further noncompliance. In the event that the court is inclined to issue that bail amount, we also have no objection to a pre-sentence screening. And with that, defense will submit.
Thank you. We'll note that for the record. And then with respect to the bail hearing, based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the appearance of the defendant and the safety of the community. The court will note the likelihood of conviction, the compliance concerns as outlined by the state, as well as the history of non-appearance. Bail will be set in an amount of $1,000 bondable with a 10% cash option. If the defendant is able to close that bail amount, she will be required to be supervised by pretrial services and must check in within 24 hours of release. I am imposing the condition that she cannot use any controlled substances or alcohol unless she has a valid prescription and be subjected to random drug and alcohol testing. We will go ahead and set a 72-hour hearing, which we set for August 28th at 9:30 a.m. And Madam Clerk, we will also set that pre-sentence screening for the STAR program. And when will that be?
August 25th at 9:15.
Thank you. Andres Martinez, followed by Vito Stone.
I spoke with Mr. Martinez today. I would ask to waive his appearance and proceed with the bail hearing.
Thank you. We're here today for first experience bail hearing, probable cause. If for two matters, probable cause has been found, the public defender's office has been appointed to represent the defendant. The court will go ahead and waive his appearance for today's proceedings. I am in receipt of the Nevada pretrial risk assessment, which indicates that he scored as a 10 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, we are going to be asking for a combined bail of $80,000. That's with no 10% cash alternative. These cases, these two different probable cause declarations will amount to one criminal complaint. We're also seeking pretrial services supervision along with house arrest and GPS prior to release, testing for controlled substances, and no firearms or weapons. That bail and those conditions are based on several factors. Number one, the factors as outlined in the probable cause declaration, which do include finding a larger amount of controlled substances and the firearm on the defendant's person. What we know about Mr. Martinez, obviously he scores higher on the risk assessment at a 10. Maybe more importantly, we know that he has a second judicial district court bench warrant. He has a felony arrest for trafficking in a controlled substance. That case is currently, along with sales and possession of a controlled substance, currently pending in the second judicial district court. He was supposed to show up for court. He did not. Not only did he fail to appear in second judicial district court, he had been having issues with pretrial prior to that. He'd been testing positive for methamphetamine. We see in the second probable cause in regards to the stolen motor vehicle, what was going on with the defendant in regards to not showing up to court and using methamphetamine again, and that was reported by his family. So a warrant was issued out of the second judicial district court for that non-compliance issue. He also has a felony conviction in 2017 for unlawful transport of a firearm. That is a federal conviction. He's been on federal supervised release for some time now. Looks like he's had some probation or supervised release violations where he had to return to custody in between that conviction. And now the last one looks to be in 2025. In addition to that, he has 2015 gross misdemeanor conviction for taking a vehicle without consent out of our court, misdemeanor conviction for disturbing the peace, domestic battery out of Sparks Municipal Court that year, and possession of drug paraphernalia. And then finally, in 2003, he's got a felony conviction for attempted robbery with a deadly weapon, again, out of our court. Did a very lengthy prison sentence behind that case. And then a gross misdemeanor taking a vehicle without consent back in 2000. So lengthy criminal history, continues to either be under supervision or in prison, and continues to commit more crimes. Certainly not a person who should be in possession of a weapon, already facing a serious drug charge, and here he is found with further controlled substances. So we do believe that higher amount of bail of $80,000 with the no 10% in those conditions is absolutely necessary for community safety and for him to show up. He is already on house arrest and GPS for his second judicial district court case.
Thank you. Defense?
Yes, at this time, we're seeking a lesser amount in bail to the effect of $35,000 bondable total. I think that's more so just a reflection of the charges that are being currently sought. There is no alleged violence or usage of the guns, save it be what appears likely to just be for personal protection. We are in receipt of the state's concerns regarding noncompliance and the prior criminal convictions. I think what's also important to note is we were able to reach a reference on Mr. Martinez's behalf. That individual was able to verify that he's been working recently at a body shop. He did have a local residence to return to if afforded that opportunity, and he does have a personal phone number that would mark his score from a 10 down to a 6 or a 7, depending on how you want to calculate it. I would just ask that whatever bail amount is set, it also takes into consideration the downward departure on the MPRA.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment, the court will note the information that was able to be verified of the reduced NPRA score. The factors as outlined in NRS 178.4853 and NRS 178.498. The court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note the pending charge of similar nature, the history of non-compliance, and the significant allegations, the danger to the community, and the likelihood of conviction. Bail will be, and as well as the appearance concerns as outlined by the state. Based on that, bail will be set in the amount of $60,000 bondable with no 10% cash option. If the defendant is able to post that bail amount, he will be required to be supervised by pretrial services and must check in within 24 hours of release. The court is imposing the requirement that he cannot possess any firearms or weapons as if based off his criminal history. The court is requiring that he cannot use any controlled substances or including alcohol unless he has a valid prescription and to be subjected to random drug and alcohol testing. The court does find that there is a sufficient nexus. Given that he's required to be subjected to residential confinement, the court will include that as part of the requirements here as well. So he is required to be subjected to residential confinement, which must be installed prior to release. That will be the order of the court, and we'll set a 72-hour hearing, which we set for August 28th at 9:30 a.m. Thank you.
And it was the bail for both cases.
Thank you. Yes. So it'll be one judicial release order that contains both PCN numbers. Thank you. Vito Stone, followed by Ashley Boyer. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. The court is in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 4 or a low risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, state's seeking $10,000 additional bail on this matter. That would be with no 10% cash alternative. Although I recognize it's a gross misdemeanor charge, the fact that the defendant continues to commit criminal activity while in custody at the jail is certainly concerning to the state. The whole facts of the case are very concerning to the state. Obviously, the defendant feels the need or feels that he can get on a recorded phone conversation and try to convince a young juvenile, he's not a juvenile, he's over 18, but to take accountability for very serious charges that this defendant is pending. Although he scores 4 on the risk assessment, he does have that, obviously that case pending. It's still in justice court. It's in Reno Justice Court. He's got a $20,000 bail with no 10% on that case, with very serious charges. He then has a felony conviction in 2025 for sales or offer for sale of a motor vehicle out of the Second Judicial District Court that he's currently on probation for when he committed the new offense. And then he has a misdemeanor conviction for just no registration out of Reno Municipal Court back in 2017. So again, not a lengthy history. However, the case that he's currently in custody for, or that was pending in custody, is very serious. And certainly his attempts to have someone else take responsibility for the crime is very concerning to the state. So we do believe an additional amount of bail is necessary of the $10,000 with pretrial services supervision. We are seeking a no contact order with the defendant's son, also the same name, Vito Stone, based on his contacts with him, which are the basis for the new charge.
Thank you. And state, would it be appropriate in the judicial release order to include the date of birth for that individual in order to ensure that it's clear?
Yeah.
That's contained in the declaration. I'm just trying to figure out how
Yes.
best to
Yes, I'm just always concerned about someone's privacy, but again, I totally understand in regards to making sure that's clear. That's
I agree
fine.
with you. I'm concerned with including the date of birth, so I just wasn't sure if you had any other, if it's a different middle name, or just if I just include in minor son, or that his adult son, if that is sufficient.
I don't have any other information as to the name other than what was in the probable cause declaration, so I'm fine with putting in paren with the defendant's son.
Thank you.
He's the only one I can.
Defense?
Yes, at this time, we're seeking a lesser amount in bail to the effect of $2,000 bondable with a 10% cash option. I think that's primarily reflected in the severity of the charge and the lack of aggravating factors that go along with the charge itself. If taken at face value, yes, it's not good to pick up an additional charge while pending another charge in custody. At the same time, when looking at the exact verbiage that's alleged against my client, there are not significant coercive measures employed by my client. I think that at the very least doesn't add to the aggravation, which shouldn't add to a higher bail as suggested by the state. In addition to that, he did still score a 4 on the NPRA with a verified residence, job, and a verified phone number if he were to be afforded an opportunity at pretrial release. At this time, we're going to submit with that request, and that'll be all.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community and specifically the named victim in this case. The court does find that the likelihood of conviction is high, the threat and harm is significant to that named individual, as well as the allegations themselves are significant. So bail will be set in the amount of $10,000 bondable with the 10% cash option. If the defendant is able to post that bail amount, he will be required to be supervised by pretrial services and must check in within 24 hours of release. I am imposing the condition that he's to have no contact with his adult son, Vito Stone. So you cannot contact him and stay 100 feet away from the named victim. You cannot contact or attempt to contact the victim in any way, including in person, phone, text, email, electronic means, or through social media, either directly or through an agent. That means someone working on your behalf. For example, if you contact your wife and ask her to speak to your son on your behalf, that is a violation of this no contact order, just to make sure that's very clear. And this no contact order begins immediately. That will be the order of the court, and we'll set a 72-hour hearing, which will be set for August 28th at 9:30 a.m. Thank you.
All right.
Next, we have Ashley Boyer, followed by Hope Dressler.
I spoke with Ms. Boyer this morning. I would ask to waive her appearance and proceed with the bail hearing.
Thank you. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent the defendant. The court does not have the Nevada pretrial risk assessment due to the exigent circumstances that was not run. However, a criminal history was run. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, we are seeking $15,000 bail for Ms. Boyer, along with pretrial services supervision with a no contact order with the shop and go, as well as testing for drugs and alcohol. That is based on a couple factors. Number one, Ms. Boyer has very recent criminal history. She has an indecent exposure case out of the Second Judicial District Court that stems from an incident from April of this year. So I was able to pull the risk assessment from that case. She did score 15 at the time of that arrest, which again was just a couple of months ago. She was just convicted, sentenced on that case on August 13th of this year. She's currently on probation for that indecent exposure. Obviously committing this new offense that is exactly the same as what is now going to raise that to a felony. She has another prior as well, but so now it is a felony plus the trespassing. In addition to that offense, she was convicted of trespassing out of Reno Municipal Court this year, intoxicated pedestrian on a highway or a street out of Reno Justice Court. This year, she did fail to appear for her arraignment for that case, and an arrest warrant had to be issued for her. She was also convicted of another trespassing and obstructing and resisting out of Reno Justice Court earlier this year. And I believe she's still under the suspended sentence for that case. She had another gross misdemeanor arrest for indecent exposure in 2025. She was released on her own recognizance, never checked in with at the time DAS. She's got more trespassings and then more misdemeanor convictions throughout the years. Her first conviction was back in 2006 for a DUI. Of note of her most recent case, she applied for mental health court. They denied her. She didn't have a qualifying diagnosis. They said basically all of her problems stem and revolve around drugs and alcohol, which I think is evident from her criminal history as well. So that is why the state is seeking those conditions as part of her release. And I will submit it on that.
Thank you. My apologies. What was the amount requested?
$15,000.
Thank you. Defense?
Yes, at this
And
time,
before
we're
you begin, are you able to, my apologies, are you able to view that Nevada pretrial risk assessment? It does appear that the public defender's office was appointed. If not, I can provide you with those scores.
I was not able to access it this morning.
Thank you. So just for the record, she scored 2 points and the maximum points for almost everything except misdemeanor conviction. She has 2 for failure to appear, a lack of ties, and 0 for substance use for that total 15.
All right. Thank you for the information. At this time, we're seeking a lesser amount in bail. I believe the state already met its burden to necessitate bail in some amount. However, I think given the factual circumstances and the underlying offense, I think a lesser amount may be more appropriate. I think at this time, probably $7,500 bondable with a 10% cash option would be more appropriate. My reasoning is one aspect of it is a trespass, very low level misdemeanor. I think at most that would be $500 bondable if we were to split between the charges, understanding that's not how it specifically works in Reno Justice Court. And then with the indecent exposure, the factual allegations are lacking certain aggravating factors that you commonly see with this type of charge. It appears that Ms. Boyer just appeared, quote unquote, in the nude without actually seeking to victimize anyone in particular or anything to that effect. There's that lack of malicious circumstance associated with this conduct. I think that warrants a downward departure in the monetary bail provided. Also speaking with Ms. Boyer, she does not have any financial means to post any amount of monetary bail. So again, I do think a downward departure would be more appropriate at this time. And with that, defense will submit.
Thank you. Based on the facts presented, the Nevada pretrial risk assessment, the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community as well as the appearance of the defendant. Bail will be set in the amount of $10,000 bondable with a 10% cash option. The court will note the history of non-compliance. The court will take based off of the public record that was provided in the other case that was in Reno Justice Court. She had a history of failure to appear in that case, as well as non-compliant with pretrial services. The court will note the history of failure to appear, the history of similar offenses, and the likelihood of conviction in this case. If the defendant is able to post that bail amount, she will be required to be supervised by pretrial services and must check in within 24 hours of release. Cannot use any controlled substances or alcohol unless she has a valid prescription, be subjected to random drug and alcohol testing. I am also imposing the condition that she is to stay 100 feet away from 641 East Moana Lane due to community safety. That will be the order of the court, and we will go ahead and set a 72-hour hearing, which will be set for August 28th at 9:30 a.m. Thank you.
Thank you.
Next, we have Hope Wrestler, followed by Brandon Hobbs. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I apologize. The public defender's office has not been appointed to represent you. Assuming that you're to remain in custody, are you able to receive any income?
No.
Thank you. The court, I do. Thank you. My apologies. The court does find you qualify for the services of the public defender. So the Washoe County Public Defender's Office will be appointed to represent you. The court is not in receipt of the Nevada pretrial risk assessment, given the exigent circumstances as discussed in the pretrial assessment. However, it's the court's information that a criminal history was run. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, even though we don't have a risk assessment, I don't show any prior criminal history for Ms. Dressler, so the state's not going to object to releasing her on her own recognizance. That's based on the facts of the case as well as that lack of criminal history. And we're merely seeking Reno Justice Court monitoring.
Thank you. Defense?
Yes, at this time, we're seeking that OR release, and we have no objection to the suggested condition.
Thank you. Just for the record, the court will grant an unrecognizance release here today. I do find that there are at least restrictive means. Just to be clear, I am going to require that you check in with Reno Justice Court within 1 business day of release. So you are required to appear in Reno Justice Court on by Monday. You are also going to be required to appear for your arraignment, which will be set for September 10th at 9 a.m. You must appear at Reno Justice Court on that date and time, comply with all these conditions of bail laws, and make all future court appearances or else a bench warrant will be issued for your arrest. Do you understand?
Yes.
Thank you. Brandon Hobbs, followed by Catherine Lambert.
We spoke with Mr. Hobbs today. We would ask to waive his appearance and proceed with the bail hearing.
Thank you. Defense counsel, do you have any information as to whether or not the defendant qualifies for the services of a public defender?
Based on his representations to us, he's been living at CARES campus for the past 2 months. He's unemployed. I think he probably meets that threshold.
Thank you. The court will go ahead and appoint the Washoe County Public Defender's Office to represent him. We'll note that we are here today for first appearance bail hearing. Probable cause has been found. And now the Public Defender's Office has been appointed to represent him. We will go ahead and waive his appearance for today's proceeding. The court is in receipt of the Nevada pretrial risk assessment, which indicates that he's scored as a 12 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. State's seeking $1,000 bail for Mr. Hobbs, along with checking in with Reno Justice Court. Again, normally we wouldn't ask for bail in this type of case, but as you can see, he does score very high on the risk assessment at a 12. And we know that he was literally just convicted in May of this year of exactly the same conduct, being asked to leave CARES, refusing to leave. He did 120 days jail for that offense. And then prior to that, a very lengthy criminal history revolving around sort of same types of conduct recently. He does have issues with competency. Even though he was convicted in May of this year, he has cases from last year, trespassings out of Reno Municipal Court where he was found incompetent. He was convicted in 2025 of trespassing out of Reno Municipal Court. He did have a failure to appear associated with that case. He has a felony conviction back in 2023 for attempted battery, causing substantial bodily harm. He was put under competency. He was put under competency proceedings in that case. He was found competent. He was later sent to prison for that case. He got another felony conviction back in 2021 for stalking. That's out of California. And then he does have some other misdemeanor convictions prior to that. So he's got a history of at least 2 felony convictions, recent history of incompetency findings, but also a recent history of similar conduct where he has been found and adjudicated guilty. So the state believes that some amount of bail is appropriate at this time, and we're seeking that $1,000 with RJC check-ins.
Thank you. Defense?
At this time, we're seeking a lesser amount in bail. Speaking with Mr. Hobbs, it doesn't appear he has any financial means to post any amount in bail. Also, the charge again itself is very mild, low-level trespass. In addition to that, it's him struggling with houselessness in this community. It's good to the effect that CARES Campus is usually willing to accept these people back, even after these brief spats. As a result, I don't think $1,000 bondable would be appropriate at this time. Usually there's a 72-hour cool down period, and then the individual is about more or less allowed to return. So at this time, I think a more appropriate amount would be $100 bondable with that 10% cash option. And with that, defense will submit.
Thank you. The court is going to grant a non-recognizance release here today. I do find that there are least restrictive means that can be imposed. The court will require that the defendant be supervised by pretrial services. So he must check in with pretrial services within 1 business day of release. The court will note that pretrial services shall be appointed, even though this is a misdemeanor. I do believe that given the facts and circumstances in the higher Nevada pretrial risk assessment, that is appropriate in order to have that increased level of supervision. That will be the order of the court, and we will go ahead and set an arraignment, which will be set for September 10th at 9 a.m. Thank you. Next, we have Catherine Lambert, followed by John McCormack.
We spoke with Miss Lambert this morning. We would ask to waive her appearance. Well, actually, we are asking if there is a bail set that it be held in the interim. Otherwise, we will be submitting.
Thank you. Ms. Costa, do you have any objection to the court just entering in interim bail?
And I'm sorry, I didn't hear a reason for why the interim bail would be appropriate.
We attempted to interact with Ms. Lambert. She was unwilling to provide us much information today. And so we would like a meaningful opportunity to interact with her and then revisit bail at that time. That's why we were seeking interim bail at this point, just to see whether or not we can have that opportunity to engage with her.
Your Honor, that's fine. The state has no objection. We are seeking $1,000 bail for Ms. Lambert, along with check-ins with Reno Justice Court.
Thank you. Just for the record, we're here for first appearance. Bail hearing, probable cause has been found. The public defender's office has it been appointed? Does not appear so. Based off the information, the court does find that there's sufficient basis to appoint the public defenders. The public defender will be appointed to represent her. The court will set bail in the amount of $1,000 bondable with a 10% cash option that will be interim. And if the defendant is able to post that bail amount, she will be required to check in with Reno Justice Court within 1 business day of release. That will be the order of the court, and we will set that arraignment. My apologies. We'll set the 72-hour hearing, which will be set for August 28th at 9:30 a.m. Thank you. Next, we have John McCormack. Good morning. We're here today for first appearance of bail hearing. A probable cause has been found, and the public defender's office has been appointed to represent, has not been appointed to represent you, as you had indicated that you would hire private counsel. Have you hired an attorney to represent you?
Not yet, Your Honor.
Thank you. Do you wish for me to continue this hearing to give you that opportunity to hire private counsel, or to see if you qualify for the services of the public defender for the bail hearing?
I was going to use Eric as my public defender.
Thank you. Assuming you were to remain in custody, how much money are you able to make per week, if any?
Could you repeat that, Your Honor? Sorry.
No problem. Are you able to receive any money while you are in custody from a job?
Yes, possibly. Yeah. I'm thinking 2,000 a week.
Okay. And how are you able to receive that income if you're in custody?
Oh, if I'm in custody, then I won't be. Sorry, I'm confused.
Thank you. I do find that you qualify for the services of the public defender. So Washoe County Public Defender's Office will be appointed to represent you. I am in receipt of that Nevada pretrial risk assessment, which indicates that you scored as a 4 or a low risk. The court has also been provided the DUI grant, which indicates that you are low risk, low needs. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, based on that low risk assessment score, and I don't show any criminal history for Mr. McCormack, The state's not going to object to releasing him on his own recognizance. However, based on the serious nature of the offense, not only the DUI, but the domestic, the state is asking or seeking pretrial services supervision. We would ask for a no alcohol and testing requirement as part of that pretrial supervision. Also a no contact order with the victim. Per statute, we're seeking only 30 days to allow the victim time to obtain an outside TPO if necessary. And then a no firearms or weapons clause based on the violence outlined by the reporting parties.
Thank you. And just to be clear, for the no contact order, is it pursuant to this judicial release order and pursuant to statute, or just pursuant to statute for 30 days?
I think both, Your Honor. I think both would be the state's request.
Thank you. And then I don't believe this probable cause sheet contained her name. Do you have her name for the record?
Yes. First name is Mariah. It's Mariah. Last of Morency, Morency.
Thank you. Defense?
At this time, we're seeking an OR release, and we have no objection to the suggested conditions.
Thank you. The court will grant no recognizance release. I do find that there are least restrictive means that can be imposed in order to ensure the safety of the community. You will be required to be supervised. I will have it be supervised by pretrial services. And just for the record, that will remain even if this is a misdemeanor. You are to have no contact with Mariah Morency, so you must stay and that begins immediately. You must for 30 days. And that'll be pursuant to this judicial release order as well as pursuant to NRS 178.4845. So you cannot contact him, stay 100 feet away from the victim, cannot contact or attempt to contact her in any way, including in person, phone, text, email, electronic means, or through social media, either directly or through an agent. That means someone working on your behalf. If you violate this order, you will be charged with the misdemeanor felon and contempt pursuant to NRS 22.010. Have these conditions modified, have your release revoked, be remanded in custody, and or any other legal punishment. The court will impose the condition that you cannot possess any firearms or weapons as this is alleged crime of violence. Additionally, given the GUI grant as well as the criminal history, the court is not imposing testing. However, I will require that you complete 3 mutual support groups per week, and you must provide that to pretrial services, and that is to at least restrictive means in order to ensure the safety of the community. That will be the order the court will set your arraignment, which will be set for September 10th at 9:30 a.m. You must appear in Reno Justice Court at that date and time, comply with all these conditions, and bail laws, make all future court appearances, or else a bench warrant will be issued for your arrest. Do you understand?
Yes, Your Honor, I do. Thank you.
Thank you.
Yeah.
All right. Back to your unit, yeah.
Thank you. And I believe that is everyone from today's docket. Just want to confirm.
That is correct.
Thank you, everyone. Have a wonderful rest of your day and good luck and stay safe, everyone.
Same to you.
You too.